The High Court has ordered Home Affairs Minister Dr. Motsoaledi and the Department of Home Affairs to allow ZEP holders to enter or depart from South Africa, provided they meet immigration requirements and have a valid passport. You remember that was in reference to the June deadline that the department had given ZEP holders, and in light of that, the Helen Suzman Foundation, as well as others, headed to court to prevent the minister from doing so. And about 3 weeks ago, the Department of Home Affairs then made it known that the extension will be extended, or the deadline will be extended to December, giving exemption holders some reprieve. We're now joined on this courtroom by advocate Simba Chitendo. He represents Zimbabwe Permit Holders Association in South Africa. Thank you very much, Simba, for your time this afternoon. I guess your initial reaction to the court's decision.
Thank you for having me. Greetings to all your viewers. My reaction is that of I'm ecstatic. I'm ecstatic for Helen Suzman Foundation for successfully getting the judgment and the orders that they've got, and also to the Zimbabwean Immigration Federation, who also got their judgment and the orders that are all in assistance to the ZEP holders generally. In the case of the Helen Suzman case, from what I can see in the judgment, although I'll be studying it and many other legal minds will be studying both judgments, it looks like the entire decision-making process by the minister has been found to be unlawful, which is obviously the same argument that the association, my clients, have been making from the beginning, that the entire decision-making process that the minister followed was unconstitutional. It broke basically all the provisions of the Promotion of Administrative Justice Act, and they've been reviewed and set aside. As an interdict, which you mentioned in the lead-up to your questions, that the ZIF have got, and there's some, I think 18 months was spoken of, which I think is beyond the deadline that was the latest extension from Home Affairs. But both judgments, in my view, don't deal with the underlying issue, which is, well, the underlying issue for ZEP holders, in our view, my view, which is the fact that ZEP holders have been in the country for more than 12 years under various regimes, ZEP, ZSP, DZP, and they ought to be allowed to apply for permanent residency. This will put an end to all the deadlines, back and forth in courts, and various NGOs arguing their cases. If the ZEP holders could simply be allowed to apply for permanent residency, put an end to all of this.
But that's just it, because I must also put it on record that this news obviously came in while we were on air, and it's about 35 pages of this judgment. But in the order, there is a second point that speaks to the applicants being ordered to set down the main application within 12 months from the date of this particular order, failing which it will lapse. Well, how should we then understand that? Because some 3 weeks ago, the Department of Home Affairs then extended the deadline to December for people to get their papers in order, citing an influx in the amount of applications. This judgment, what does it say about the December deadline? What does it mean?
Thank you for asking that question. You're referring to the ZIF judgment, which is only for Part A of their case. And I think Part A was an interdict. And when they say set down the matter, I believe what the court is referring to is the setting down of Part B. And I think that is something that the ZIF will be best placed to answer, to be honest with you. But I have been following all the cases. From what I understand is that ZIF has that time which you just mentioned, I think 18 months or whatever it is. I also just got the judgment to set down their Part B to deal with the main review. However, the Suzman case is quite clear. They have got a review to set aside the entire decision-making process, which is great news. And it's been remitted back to the decision maker. Because obviously the decision maker didn't follow the processes that they ought to have, and the decisions that the minister made were unlawful, and that's what the court has said.
So it is likely that the December deadline may go beyond December.
I beg your pardon?
Is it likely that the deadline set by the Department of Home Affairs of December may go beyond that?
Okay. The decision, there's two judgments. The first judgment sets aside, I'll say the Helen Suzman judgment rather, sets aside the decision-making process, the decision to end the ZEP and the subsequent decisions that followed after that. For my reading of the court judgment and the orders that have been set by the court, that is all being set aside. This latest extension is read in line with the 2nd of September decision, which is the June deadline. So I would think that the judgment didn't take into consideration that the minister was going to make another extension. But from what I've read, all the extensions that the minister has made have been found to be unlawful, which would include the December extension. So I would say follow the order. The order is quite clear. What the minister has decided to do with ZEP, all of it, has been found to be unlawful, and he has to go back to the drawing board.
Okay.
Simba
Chitendo represents the Zimbabwe Permit Holders Association.